Morning, Your Honors. My name is Steve Gregoza. I'm representing Appellant Randy Redford. I was also the trial attorney in this matter. And I would like to at least save 5 minutes for rebuttal, Your Honor. Yes. Mr. Redford and his brother were charged with and convicted of burglary of a house. However, the state's theory of prosecution was not that he had actually ever been in a house, because the state had absolutely no evidence that either he or his brother had been in a house. The prosecution theory was that because Redford and his brother had possessed recently stolen property from the house, which were two safes, that presumed that he was guilty of the burglary. So this trial came down to Redford reasonably trying to explain how he came in possession of those safes. Now, about 4 days prior to trial, Redford's in jail, his brother's out of jail. Redford made 2 phone calls to his brother, which were recorded. Both phone calls were about 15 minutes long. And in those phone calls, Redford is basically telling his brother, they go over a bunch of things, but basically one of the things he's telling his brother is that we have to tell the truth about what happened. We found the safes in a dumpster at a motel we were staying at, and that's what we have to say. His brother's continually saying, no, we're not going to say that. I'm not going to admit nothing. And Redford saying, no, continually and consistently, we have to tell the truth. We found the safes in a dumpster. Well, the state, obviously, since they had the recordings, knew what Redford's defense to possessing the safes would be. So what the state did was they cut out 3 snippets from these 2 phone calls. The first snippet was about 32 seconds long, and it came from the first phone call. The second and third snippets were about 13 seconds each, and came from the second phone call. And what the state did was, in trying to discredit Redford's defense that he'd found the safes in a dumpster at the motel they were staying at, the state argued 2 things. First, these 58 seconds showed that Redford and his brother had been discussing, actually the state used the word battering, various versions of how they had found the safes, ending up with the dumpster defense.
Let me ask you this. In one of the snippets, your client is heard telling his brother to tell the truth.
Right.
And my recollection is your client testified.
That's correct.
And he was able to present his theory and his defense.
Well, I more or less. I don't think we were able. Okay.
More or less. So I want to make sure I understand your position on if there was error, why it was not harmless error not to have repeated statements on these tapes by your client.
Okay, for 2 reasons, Your Honor.
Okay.
And it both goes to the theory of prosecution that the state used. One was that the state twisted these snippets out of context to argue that Redford and his brother were battering 5 versions around. But more importantly, the second argument the state used was that Redford's trial attorney, me, and they named me specifically Steve, had told Redford that the dumpster defense was a good defense, and that's the one he should put forward at trial. Both of those arguments that the state used are discredited by the entire phone call. I had requested the court, under the rule of completeness, to play the entire phone call from both of those.
Why would you want to play a phone call where you're injecting into the conversation giving advice?
Well, for a couple of reasons, Judge. First of all, I think the phone call would put in context completely what those snippets said, and it would discredit the state's theory.
Well, I think what you were trying to achieve when you were arguing to the judge, and I think the state finally conceded, was, Your Honor, I should be able to put this in context in terms of the brother is coming up with possible defenses, but my client keeps steering him back to the truth. We found it in the dumpster. Is that...
Well, that's one portion of it.
But then the judge finally allowed you on direct examination to go through each defense concocted by the brother, and you asked him before the jury, why did you tell him to tell the truth? And he conveyed to the jury, it is the truth. I found it in the dumpster. Everything else was a lie.
Well, the reason is this, Judge, because I think, first of all, the court was limiting us in that respect to only put on evidence on direct examination that fit within the parameters of the state's case. We had more evidence to that. For example, specifically, the state was always focusing on that the lawyer had come up with this. But yet, when you listen to the entire transcript, or the entire phone call, that's absolutely not what had happened. Redford was consistently saying that the lawyer is telling me to tell the truth. And he says that consistently, continually, about 20 times more, the lawyer is saying, tell the truth. The lawyer is saying, tell the truth. The lawyer is saying, tell the truth. But that's not what the state was arguing to the jury. The jury was saying this lawyer came up with this defense, which was absolutely false. And the complete phone call showed, or both phone calls, discredited the state's argument in that. But as to us putting on the defense with Redford, we were absolutely prohibited from going into anything else on those tapes except the issue of, is it true that you found the safes on the side of the road that your brother brought up with? No. Is it true that you got these safes at Home Depot? No. That's not the defense we had. Our defense was to show to the jury, present a reasonable explanation as to him coming in possession of these safes at the dumpster at the hotel. We were not allowed to put on that defense. We were stopped from doing it. We look at our closing, look at what Redford was able to testify on direct examination. Nothing about that he had found the safes at the dumpster, other than I found the safes in the dumpster. But there was a lot of other evidence that supported that. And I think we were also entitled to contradict anything that the state said.
But isn't the purpose of the rule of completeness is to avoid misrepresenting what is reflected by those snippets. So what it seems to me your argument is, what you were able to do to maybe mitigate the damages is not the equivalent of the jury hearing the full tapes that reflect what was happening in context at the time of the discussions.
All right, well, then consider this, Your Honor. The state is twisting those snippets to something that did not occur. The state is saying that Redford battered 5 defenses around with his brother and came up with the dumpster defense. That is absolutely false.
That's my point. You're saying that your client, or you're responding correctly, your client did have the opportunity to address some of this on his direct testimony, but isn't the real problem that you are presenting that the state doing what it did misrepresented what was going on during those discussions?
Well, that's why we wanted the rule of completeness, because they're twisting these snippets.
It's a softball question, Mr. Groza.
Okay, said it again. No, I said right. Well, that's absolutely correct, Judge. And that was the whole issue of, I mean, the jury is the fact finder. The jury had to determine whether or not Randy Redford's explanation was reasonable. Consider also, Your Honor, that after the jury's deliberating, they came back and wanted to rehear the snippets and Redford's testimony. They wanted that played back. And I suggest the reason they wanted to hear that played back is because they wanted to fill in these gaps with those 58 seconds. If they had heard the entire phone call, they would have gotten the complete picture. And I suggest that when the jury only gets a partial picture of what happened here, and the state is twisting it, that comes down, and the judge is not allowing us to explain it, either with the other phone call, the other portion of the phone calls, or in direct examination to explain, well, here's really what happened. I suggest that's just not a fair trial. The whole purpose of the trial is for Redford to put on a defense. Actually, the whole purpose of this trial, there's a presumption against Redford, is for Redford to put on evidence to explain his reasonable coming into possession of those safes. And I suggest when you just look at what we were able to do, and then you look at what is also out there that the court disallowed, I think the consideration comes down to that's not the whole picture. I also suggest, how is it possible that the state can argue that his trial lawyer had told him that basically to lie, that this is a good defense to come up with, and we should use this at trial, when the fact is the recording, the full recording, look at the portion between 58 seconds, the first portion I requested, The 58 seconds to 2 minutes 53 seconds. Redford is continually saying, the lawyer is telling me to tell the truth. He says that maybe 20 times there. And his brother is saying, I'm not doing it, I'm not doing it, forget it, forget it. And every single time, Redford's saying, we got to tell the truth. We found it in a dumpster. Now, consider that impact that it would have had on the jury. I suggest to the court that just that impact of him continually saying to his brother, and every time his brother comes up with another version, which also discredits the state's argument that Redford's battering these defenses back around. He's not. It's his brother bringing up these offenses. I suggest to the court that if the jury had heard the full thing, his full conversation, that they would have said, first of all, his lawyer is not telling him to lie, to come up with a dumpster defense. His lawyer has been telling him, and according to what Redford's saying, is tell the truth, tell the truth, tell the truth, tell the truth. And second of all, it's not that Redford's battering these things around. It's his brother keeps coming up with these ridiculous assertions, and every single time Redford says, no, we got to tell the truth. Why lie? Why lie? Why lie? And I suggest if the jury had had that whole picture, especially when they wanted to rehear his testimony in comparison to the snippets, I suggest that the verdict would have been different. And I suggest that the state cannot prove beyond a reasonable doubt that that error would have affected the verdict. So if the court has no other questions, let me reserve the rest of my time for rebuttal. Thank you.
May it please the court, my name is Jillian Latham and I represent the state of Florida. From the outset, I would like to clarify that the state never argued to the jury that Mr. Redford's attorney told him to lie and to make up this dumpster defense.
But isn't that the implication of the argument, that this is the defense, your attorney, you were talking with your attorney, I forgot the exact wording, but the implication is there, that your lawyer is telling you this is the story you need to tell. Well,
they asked, why would he need to run this by his attorney? If this was the truth, why would he need to be discussing this? Why would he need to be putting a defense together and then discussing various alternative theories of how he came up with these?
Was there any evidence that the defendant discussed with Mr. Gregoza various theories and what might be more or less successful at trial?
Other than the 3 snippets. In the first snippet, this is before he ever started going into let's tell the truth.
How many times is Mr. Gregoza mentioned in those snippets?
I did not count them, maybe once, twice. I mean, not very many. I think it's mentioned in the very first snippet, which is before the...
I don't read the snippets as suggesting that the defendant was bouncing multiple theories off his lawyer's head as far as what might work and might not.
Right. No, I agree with you. I don't think it suggests that at all. I think it suggests that Mr. Morganti...
But isn't that what the prosecutor implicated?
Made one statement, I think it was maybe 1 or 2 statements during the entire closing arguments, and then when she made those statements, or when he made those statements, he said, why would he need to run these theories by his defense counsel? He didn't say he told him to lie. He didn't say they were coming up with these together. It was, I mean, the prosecutor did not focus on the trial attorney in arguing to the jury. The prosecutor focused.
But isn't even that implication undercut by the full context of the recordings, where the defendant keeps saying, we got to tell the truth, here's what happened. Now, it may be the truth, it may not be, but
right.
Ultimately that's for the jury to determine. But isn't that what the defendant is doing repeatedly when his brother keeps saying, well, what about this, what about that?
At the very end of the 2 phone calls, he's saying, let's tell the truth, let's tell the truth. But in the very first phone call, when Mr. Morganti, his brother, first said, well, let's say you got it at Home Depot and it contained your divorce papers, Mr. Redford said something to the effect of, oh, I ran that by Steve, I'm not going to say that. So this is before he even starts going into the dumpster defense, my lawyer told me to tell the truth. He's saying he already ran something by his attorney. So I think that's what the prosecutor was focusing on. Why would you need...
Remind me which snippets we're concerned with. As I understand the record, there's one snippet that's not preserved or something. Then there's a second snippet where Mr. Redford does say to tell the truth. And I guess then we're left with just 2 snippets that are really at issue here.
Correct. There are 3 snippets. I think there was an additional 2 minutes and 50-ish seconds that Mr. Redford wanted in. I can get you the exact numbers if you like, if you give me 1 moment.
Well, let's assume for the moment that I'm correct, that there's 2, maybe plus a third one that Mr. Gregoso wanted to have in. And again, I guess maybe it's a counting exercise as to how many times this issue, to tell the truth, comes up. And what may be just 2 snippets, plus possibly this third.
Pardon?
So do we know?
Do we know? Oh, I'm trying to find it right now.
Okay.
The exact numbers. I had it in my brief. I broke it down.
Well, the record seems to show the first snippet is 31 seconds. Are we talking about the snippets Mr. Gregoso wanted in, or the snippets
believe
that were
so.
admitted?
Yes, we're talking about the ones Mr. Redford asked for. So the one snippet was from 6:18 to 6:38. And then okay, so he requested, the first one was from 58 seconds to 2:53.
Okay.
The second one was from 6:18 to 6:38. The third one was from 9:45 to 9:55. And then the fourth one was 11 through 11:19, so it was 4.
Okay.
And I do want to turn to the first snippet, which is the one where you say the defendant bounced one of the defenses off of Mr. Gregoso. Is that right, the first one?
Are you talking about the state's first snippet?
Yes.
Correct.
Okay, so that first snippet says, this is Morganti. Let me tell you this first before I forget, because I got short-term memory loss. Redford, go ahead, I'm sorry. Morganti, even though you didn't carry no safes in that house, Redford, okay. Morganti, but if you really want to fuck their world up, you could turn around and say, yeah, I did carry a safe in that house that I brought, and he goes on as far as what you could say.
Mm-hmm.
Redford, I'm not even saying that. I told Steve something like that, and I'm not even saying that. And then Morganti, that fucks up the whole thing right there. How is, I understand the prosecutor is extrapolating as far as what was discussed with Mr. Gregoso and trying to imply that it was bouncing one of the defenses off, but I don't get that from that snippet. I mean, it doesn't seem quite as clear as you seem to want to make it sound.
Well, that's the purpose of closing arguments, is to, argue what you can infer from the evidence to the jury.
Well, and why is it not misleading when the entire course of the conversation, other than this snippet, has the defendant saying, I'm going to tell the truth. We need to tell the truth. I want to tell the truth. Here's what really happened. You know that's what happened. That's what I want to say. Why is that characterization and that snippet not misleading, especially when you then put it in the context of what the prosecutor argues?
Based on my reading of it, I don't find that to be misleading. I think he's saying I told.
So if we read it differently, this should be a reversal if we conclude that it isn't quite as clear as you're suggesting, that what he was doing was bouncing a defense off Mr. Gregoso.
Well, I think that's when the high standard of abuse of discretion comes into play. I mean, if reasonable minds can differ on whether or not the trial court erred in this regard, then it's not an abuse of discretion. And I think reasonable minds could differ in this situation on the implication of what that means, especially given the context of later it starts switching up the various defenses. And he's welcoming to the discussion the entire time. It's not like he's really shutting down his brother.
Tell me how you come to that that conclusion.
Okay, up until the dumpster defense. At first, when he's discussing the Home Depot one, he's not saying, I want to tell the truth, I want to tell the truth. He's saying...
Does the defendant at any point suggest, ooh, that's a good theory, let me think about it a little bit, or that's a better theory, let me think about that? Can you get any of that from these snippets or from the conversation as a whole?
Him agreeing that that's a better theory? No.
In the argument in the trial court, the prosecutor responded to Mr. Gregoso's request for abiding by the rule of completeness. Our position is that's him bolstering his own story with self-serving hearsay. He can get on the stand and testify about what happened. Doesn't the rule of completeness let that take place? That, yeah, you, as part of the rule of completeness, you get to hear the whole thing, and if it's bolstering, fine, if it's damaging, fine, but the jury gets to weigh that. So is that argument a valid argument that it's improper bolstering?
If you're assuming that it's out of context to begin with, then that would be an incorrect argument. But these were not taken out of context. I don't believe these snippets were misleading. And so for the rule of completeness to apply, those snippets in and of themselves have to be misleading without regard to how the prosecutor is going to argue to the jury later.
Your position is that the snippets themselves, as long as they're not misleading, then the prosecutor, to the extent that the prosecutor misuses it, that would not be reversible error?
Not under the rule of completeness.
Well, isn't it the case if the snippets do not suggest that Mr. Redford is playing out various scenarios, if the prosecutor gets up and makes a closing argument that, look at all these defenses he's playing with, it's fair game for the defense to get up and say, you know, you've heard these snippets, and there's nothing in there suggesting that Mr. Redford is trying out different theories of defense.
Correct.
He's consistently saying, we found it in the dumpster.
Right.
And you get that from the snippets, don't you?
Would he be able to argue that from the snippets? Oh, of course, he could. But he didn't. But that's part of, you know, your choice as a tactical strategy on how you want to address that. If there are no further questions with regard to the first issue, I'll move on to the second. With regard to the second issue, Mr. Redford was not prohibited, or his direct was not limited to the parameters of the state's case. Essentially, the trial court ruled that he cannot testify to his actual statements that were made within the audio recordings because those had already been excluded from evidence. So the trial court did not want Ms. Redford to be able to get around the prior ruling and to go ahead and give those statements to the jury. So the way that they constructed the way he could discuss it was in a first-hand person knowledge kind of aspect. And we do not think that that was error. We think that that was proper because you cannot testify to your own prior consistent statements in order to bolster your own testimony. And if there are any questions with regard to that. All right, if there are no further questions, the state would ask that you affirm his convictions. Thank you.
Thank you.
Unless the court has any further questions, I'm going to waive any further rebuttal.
Very good.
Thank you, Your Honors.
Thank you.